This is Barry Zalma on insurance. I'm an attorney who's retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the law of unintended consequences as applied to the tort of bad faith. In a typical contract, one party has a duty to perform, that is, construct a building, deliver goods, convey real estate, pay indemnity from an insurer, and the other party has a duty to pay money or perform a task. Breach by the performer may take the form of nonperformance, defective performance, or delay in performance. The primary purpose of damages for breach of a contract is to protect the promisee's expectations interest in the promisor's performance. Damages should put the plaintiff in as good a position as if the defendant had fully performed as required by the contract. Damages should never provide a profit to the non-breaching party. Insurance, like all parts of modern society, is subject to the deprivations of the law of unintended consequences. In the USA alone, people pay to insurers more than $1.2 trillion in premiums, and insurers pay out in claims as much or more than they take in. Profit margins are small because competition is fierce, and a year's profits can be lost to a single firestorm, earthquake, hurricane, flood, or unexpected bad faith lawsuit. Neither the courts nor the governmental agencies seem to be aware that in a modern capitalistic society, a healthy and viable insurance industry is a necessity. No person would take the risk of starting a business, buying a home, or driving a car without insurance. The risk of losing everything would be too great. By using insurance to spread the risk among all the costs of taking the risk to start a business, buy a home, or drive a car becomes possible. The persons insured are dependent on their insurer to take the risk the insureds are not willing to take alone. Insurance contracts can be simple or exceedingly complex, depending on the risk taken by the insurer. Regardless, insurance is only a contract whose terms are agreed to by the parties to the contract. Over the last few centuries, almost every word and phrase used in insurance contracts have been interpreted and applied by one court or another. Ambiguity in contract language became certain. However, the average person saw the insurance contract as incomprehensible and impossible to understand. Ostensibly, to protect the public, insurance regulators decided to require that insurers write their policies in easy-to-read or common language on what some statutes call plain English. Because they were required to do so by law, insurers changed the words in their contracts into language that people with a fourth-grade education could understand. Precise language, interpreted by hundreds of years of court decisions, were disposed of and replaced with imprecise, easy-to-read language. The law of unintended consequences came into play, and instead of protecting the consumer with easy-to-read policy language, an attempt to force insurers to deal fairly with the insureds resulted in thousands of lawsuits determined to impose penalties on insurers for attempting to enforce ambiguous, easy-to-read language. The multiple lawsuits cost insurers and their insureds millions, if not billions of dollars to get court opinions that interpret the language and reword their easy-to-read policies to comply with the court decisions. For more than 30 years, the unintended consequence of a law designed to avoid litigation has done, because of the law of unintended consequences, exactly the opposite. The attempts by the regulators and the courts to control insurers and protect consumers were made with the best of intentions. The judges and regulators found it necessary to protect the innocent against what they perceived to be the rich and powerful insurers. In more than 60 years of application across the U.S., the tort of bad faith has not, in my opinion, had a salutary effect on the insurance business. Insurance costs more than is reasonable or necessary, so that sufficient funds exist in reserve to pay claims and tort damages from those insureds who believe they were done wrong. In Louisiana and Mississippi, multiple millions were paid to settle claims that flood damage was covered as a result of Hurricane Katrina, although the policies clearly and unambiguously excluded flood, and the plaintiff insureds failed to buy flood insurance, which was available in the marketplace. Abuse of insurers has become so rampant and so successful that lawyers obtain multi-million-dollar fees and have even attempted to, or successfully, bribe judges to increase their recovery. Consider, for example, the case of Michael Siegel, the convicted insurance fraudster and racketeer, who appealed for the third time to the Seventh Circuit, hoping that a recent U.S. Supreme Court decision on honest services fraud would give him a new chance to appeal his conviction. In United States of America versus Michael Siegel, the Seventh Circuit in 2011 held that Siegel, recognizing the great weight of evidence, had established he was a fraud and a thief, and that any effect of the prosecution's claim of honest services fraud was minimal, and a factual decision that might affect the length of his sentence. So following a trial, a jury found Siegel guilty on all charged counts except one that the government dismissed during the trial. Subsequently, during post-trial proceedings, the district court knocked out 7 counts. Siegel was still sentenced to serve a 121-month term and pay $841,527.96 in restitution and forfeit $30 million plus his interest in the racketeering enterprise. Not surprisingly, Siegel did not leave detailed records of his crimes. As originally noted by the district court back in 2004, Siegel's lackluster accounting system, which was a deliberate attempt to conceal his fraudulent conduct, precludes such a detailed accounting. On remand, the district court did exactly what the Seventh Circuit asked of it. Using the evidence that was available, it cogently explained the amount of money that Siegel took for personal use. None of the shortcomings alleged by the government or Siegel rose to the level of clear error, and the judgment against him was sustained. In United States versus Scruggs, a 2012 decision of the Fifth Circuit, an attempt to corrupt Judge Henry Lackey, a Mississippi state judge, in connection with Hurricane Katrina-related lawsuits styled Jones versus Scruggs. The actors in the scheme included 3 members of the Scruggs law firm, Zach Scruggs and his father, Richard Scruggs, and Sidney Backstrom. Also involved were Timothy Balducci, an attorney who worked regularly for the firm, and Stephen Patterson, Balducci's associate, who worked with the firm on various projects and joint ventures, but was not an attorney. The conviction was affirmed because trial lawyer Richard Dickey Scruggs made millions from lawsuits targeting the asbestos and tobacco industries. He was part of a network of powerful businessmen and politicians spanning from Oxford, Mississippi to Washington, D.C., who traded favors, influence, and money. After much litigation, Scruggs agreed to plead guilty on 1 count of conspiracy to bribe Judge Lackey, and when the judge asked Scruggs if he agreed with the prosecutor's account, Scruggs seemed eager to offer a dissent. He said, quote, "I joined the conspiracy later in the game. It's not exactly as the prosecutor allocuted, in that there was no intent to bribe the judge. It was an intent to earwig the judge." Judge Lackey. Earwigging is a legal term that is unique to Mississippi. No other state incorporates the term into any code, rule, or statute. Earwigging is intended to prevent an attorney from discussing facts of a case outside of a formal legal proceeding. Basically, it's a prohibition against ex parte communications. The general penalty for earwigging is contempt of court. The penalty for contempt shall never exceed imprisonment for longer than 30 days and a $100 fine for each offense. But consider the case where 2 former claims employees at the Hartford admitted taking hundreds of thousands of dollars in payoffs from a Texas lawyer who was charged with trying to buy favorable insurance settlements for clients suing over industry-related health problems. A claim supervisor working for one of the Hartford's subsidiaries was responsible for settling claims and recommending appropriate settlement amounts for the claims against the Hartford. The indictment against lawyer Warren Todd Hefner, 45, alleged that from 2002 to 2004, Hefner paid the 2 claims employees for favorable recommendations on more than $34 million in settlements involving silica-related disability, airborne silica dust in mines, foundries, and other workplaces can, in fact, lead to lung disease. But in United States versus Hefner, a 2010 decision of the Fifth Circuit, it found that Warren Todd Hefner represented over 900 individuals who brought silicosis and other silica-related claims against manufacturers and sellers of silica-containing products and related protective equipment. Among the insurers of these companies was the Hartford Financial Services Group. Hefner, according to the opinion, funded trips for the claims people to Laguna Beach, California, New York City, and Palm Beach, Florida. Also, unbeknownst to the Hartford, Hefner paid the claims people approximately $2.6 million and Prestige approximately $760,000 out of the funds that he received from the settlements with the Hartford, sums that are a factor of 100 times the basic earnings of a claims person working for the Hartford. This case revealed a situation that should concern every insurer, since it revealed the failure of internal security to note two claims people who obtained millions of dollars by paying claims that were not owed. The fraud and bribes caused the Hartford to pay more than $34 million in settlement funds, knowing that more than $3 million of those funds would be used to pay bribes and kickbacks to the claims person. This video was adapted from my book, It's Time to Abolish the Tort of Bad Faith, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you and your colleagues, please refer it to them. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, and you will be able to learn about future blog postings and videos. Thank you for your attention.